The Historical Society of the United States Courts in the Eighth Circuit was incorporated as a not-for-profit organization in May of 1985. The purpose of the organization is to collect and preserve historical information of the United States courts in the Eighth Circuit. The Nebraska District Court Historical Society was formed as one of the 11 branches of this corporation. As part of its efforts to gather historical information on the Nebraska District Court, the Society presents this oral history of the Honorable Richard Peck, United States Magistrate for the District of Nebraska. I am Richard Chagru of the Creighton University School of Law. Judge Peck, welcome. It's a pleasure to have you here and to get you, incidentally, prior to the time of your formal retirement, which I doubt will be time for the end of your myriad of activities in and around the judicial sphere.
Let's hope that's true.
I know it will be. Let's start at the beginning, Judge. You came from the smaller rural community in Nebraska around Richardson County,
Yes.
And then went to the University of Nebraska, first in undergraduate school and then to study law prior to World War II.
Right.
What led you to the study of law?
Well, several things. I was born and reared on a farm. And at about the time I was ready to graduate from high school, we of course were in the midst of a farm depression that equaled, if not surpassed, the one that apparently we are encountering now. And as I was doing such things as shocking wheat and picking corn, I made up my mind there had to be a better way to make a living than continuing to be a farmer. And of course I had parents who encouraged their children to go on to with higher education. Then I had an uncle who was in the practice of law in Fall City, John Wilsey, an uncle by marriage to an aunt on my father's side. And he was a rather role model for me as I was growing up. And so I just constantly was attracted toward the law as a profession. And never really, as I can recall it, considered any other course to follow.
As you well know, in this day and age, young men and women studying law have a myriad of opportunities, many of which, incidentally, the United States courts have been pioneers in developing for internships and clerkships and other programs where a person can get his or her feet wet, so to speak. What kinds of exposures were there at the University of Nebraska Law College, if any, when you were a student?
Practically none. Practically none. And especially at the particular time when I was there. As you know, that in the year that I was a freshman in the law school, we commenced our involvement in World War II. And so we were really just hanging on to try to complete our law education before call-up in the service. Mm-hmm. And I was able to do that. There was no such thing as an intern program, of course, in any of the court system. There were some students who were, though they couldn't be paid for it, were serving as law in a capacity of a law clerk to justices on the Supreme Court, but the court had no provision at that time for law clerks. I did not do any of that. I had to have employment in order to continue my education, and so my employment in order to meet the grocery bill or the restaurant bill at the time and tuition was that as a night clerk, a night shipping clerk in a wholesale supply house for veterinary medicines.
No kidding. What an interesting background. You, like so many people of that era, had your career plans interrupted, of course, by a call to service. And my recollection is you had a very interesting experience during World War II. Would you like to tell us about that a little bit?
Well, as it eventually developed, yes, an interesting experience. Initially, I was assigned to some temporary duty in a judge advocate's office in a basic training base. And I shall never forget the citation that I got at that time. I was assigned to defenses, in providing defenses in court martials. And suddenly there came down a citation from the commanding general to all the members in the judge advocate's office for the splendid record of convictions that had been compiled by that judge advocate's office. And there my name was on the list, and I was one of the defense attorneys, and so I was commended for that. I shall never forget that. Then eventually I was transferred into the intelligence service and served overseas in the counterintelligence corps, in an intelligence activity that was really created by General Eisenhower after the difficulties that were that they encountered in the invasion in North Africa. And so this counterintelligence corps unit was created subsequent to the war, some years subsequent. That unit, together with the Office of Strategic Services, which was the affirmative spy operation of the military, was combined into what eventually became CIA. So my experience was that as what was called a special agent in the counterintelligence corps with primarily service in Italy.
And then when the war was over, you had to make a decision as to whether you were going to come back and practice your profession in Nebraska, or I suppose maybe some other kinds of opportunities faced you. But you did come back to Nebraska.
I did.
And where did you begin practice then, Judge?
In Plattsmouth.
In Cass County?
In Cass County. And that came about because when my release from the service finally came about, lawyers were a dime a dozen. Litigation explosion hadn't yet occurred. Law firms really weren't interested in taking on additional personnel. And so every law firm that I visited here in Omaha was rather cool. They were glad I was home, of course, and that I had served my country and all that, but they were rather cool to any employment with them. And invariably, those that expressed any interest at all showed me a little room in which the desk was piled high with abstracts. And I just didn't want to start my career by being confined to a desk examining abstracts. And I learned of a need for what I thought was a need for an additional attorney just down in Plattsmouth. And since I had come from the Falls City area and was accustomed to what can be expected of you in a community of that size, I went down there not knowing a soul and decided that I was young and foolish enough to do this sort of thing. Opened a law office, filed for county attorney, and spent a summer just running around that county, visiting everybody I could get a hold of, let them know that this fellow by the name of Dick Peck was just fresh home from the war and almost won it. But the best thing about that was that by the end of that time, I had sufficient practice coming in to be able to pay the grocery bill and the rent bill at the end of the month. So I had a rewarding experience of building a practice in a town and county of that size. And as you know, I eventually did become the county attorney there and was serving in that capacity when I then accepted the chief trial attorney position in the U.S. Attorney's Office. And that's what brought me back to Omaha.
There really were multifaceted aspects of your career as a lawyer in a smaller community. You, as you mentioned, had served as a county attorney, but I suppose there was the private practice element of it as well. You had to be a man for all seasons, so to speak, didn't you?
Yes. And at one time also I served, I think it was almost 2 years I served as a county judge there, where the county judge had become incapacitated.
So you were Judge Peck long before you were the magistrate.
That's right. That's right. That was, and before I was county attorney.
And that's usually the other way around, isn't it? A person would typically go from the county attorney's service to the judicial office.
Yes. And you see, it was one of those situations where those of us, the members of the bar then, knew that we needed to have an attorney as a county judge, but none of us really wanted it. And we had our eyes on a young man that grew up in Plattsmouth and was then attending law school at Creighton. And we knew about when he was to graduate. And we singled him out as being a likely candidate for that position and sort of drew straws as to who would fill the position until he graduated, and I drew the short straw.
That's a wonderful story. So it was about 30 years ago that you came into the United States Attorney's Office.
Yes.
In the litigation section, I guess
Yes.
we would call it today. What were the scope of your duties then?
Well, the designation given to me at that time, which is different than it is now, was as the chief assistant. And the chief assistant was the assistant who was responsible for oversight of all of the trial work in which that office would be involved. And so we had younger lawyers come in as assistants who would second chair with me through several cases until I felt that they were in a position to try a criminal case themselves. And the same was true of what civil litigation also that we had, but primarily at that time we were concerned with criminal work. The civil load in the United States Attorney's Office at that time was not as large as it is now. There weren't as many government agencies involved in the everyday affairs of the citizenry as there is now.
The United States Attorney's Office in our district has always prided itself on being lean and mean, but I suppose 30 years ago it was even leaner.
Oh, yes.
And the workload on each of the individuals was probably humongous, wasn't it?
It was enough.
You went from that position then to the position as clerk of the United
Yes.
States District
Yes.
Court. How did that come about?
Well, I was somewhat induced to do it. When I reached the point where I wanted to get back into the practice, and I was making preparations to do that. At that time, we had just the two district judges, Judges Robinson and Van Pelt, and Judge Robinson as senior judge. The then clerk of the court was ready to resign. It was obvious to all of us that the court had reached the point it was in need of a complete administrative overhaul. Judges Robinson and Van Pelt had known me in the years when we were all in practice. And they were concerned to have someone in that position that understood them and what the goal was that they wanted to reach, and a person that they felt had the same kind of feeling about what ought to be done. So they asked me if I would do it, and the request was made with the assurance that I would be given a free hand to reorganize every facet of the court from the administrative standpoint, and unless they found that I was completely off base, that would be what would happen. And so I accepted the position, and that kind of parameters outlined for me, with the expectation that it would be just a few years that I would be there. And then,
famous last words.
yes,
huh?
and so we did. We did overhaul this district, and we literally needed to bring it out of the horse and buggy stage, which was not the fault necessarily of the individual who was the clerk of the court at that time. It was, as you know, you reach a point in every organization where radical change has to be made.
Certainly.
And we had reached that point, and
Certainly.
the court throughout the entire country had reached that point. And the only thing that kept me then into that administrative field beyond the time that I expected was the fact that we started doing things here which drew the attention of the administrative office of the United States courts, the Chief Justice, and the director of the administrative office, And I then was asked to serve on a number of ad hoc committees. You won't find any listing of those committees anywhere. They were informal things, in which a group of us, together with some then budding computer people, at a time when the computer industry was really in its infancy. And we went around to various courts, or were sent around to various courts, large and small, throughout the country, to make some examination of what they were doing and recommendations to the judges of those courts as well as to the administrative offices of what things could be done. And so it became rather an intriguing thing for me, and I got so caught up in it I forgot about going back into practice.
Well, you and our senior judges, it seems to be, are entirely too modest to admit the role that you and others have played, but you particularly in modernization of United States federal practice. It's true in the story that you've just shared with us now, and it's true with respect to your role as a federal magistrate.
Yes, it was.
And I'm very anxious to get to that in a couple of minutes, but I want to explore a little bit more the role that you played as clerk of the United States District Court.
Right.
This is one that has multi-facets to it because of the fact that the court sits not just in Omaha, but as we know, in Lincoln and in North Platte. And there was a time, as I understand it, when the court sat in many other places in the state, but we've consolidated that now.
We abolished, we secured the abolishment of the divisions, and it became a unified district, just a district of Nebraska without any divisions.
In terms of the caseload when you first became clerk of the United States District Court, how did that differ materially from the kinds of things that we see 30 years later?
Oh, fantastically different. My recollection, and I'm saying this now without having searched the records, but my recollection is that the entire caseload, civil caseload I'm speaking about, in the district at the time I became clerk was somewhere in the neighborhood of 300 cases, filings a year. I think we have now reached, it's either 1,700 or 1,800.
Heavens to Betsy.
Each year, civil cases alone. So there has been a phenomenal increase in the number of filings, as there has also been a phenomenal change in the character of the litigation that is coming before the court.
In terms of the staff in the clerk's office, just to keep up with the changes that are going on, there must have been some shifts there as well.
There were, although...
Again, that's a mean and lean operation.
Well, at the time, at the time that I took over, the clerk's office was actually overstaffed. And it was overstaffed for the reason that things were being done in the clerk's office that really didn't need to be done so far as fulfilling the role of the court in its record keeping and the case flow is concerned. So we had the unusual honor, I guess, of being the only district in the country at that time that reduced the staff, the number of people in the clerk's office, and we did. And we made it a leaner operation and focused the personnel on those matters that were really essential. Now, of course, as time's gone along, the wheel has turned, and the number of deputies now on the staff is considerably larger than what it was at that time. I'm sorry, I can't tell you how many are on that staff now, but it is considerably larger than it was. But the important thing was that when we streamlined the operation as it needed to be done at that time, we had more people than we needed, and so we eliminated the positions.
There, of course, has also been a radical change in another and significant hat that you wear. That's the shift from the role of commissioner to the role of magistrate.
Yes.
Just for the sake of our younger viewers, tell us a little bit about the old commissioner system.
Oh, that was... that's kind of hard to describe, even at this stage in history. And of course,
It's like talking to my students about World War II.
That's
They were
right.
ancient history.
The United States Commissioner system was actually created as long ago as 1793. And it was a position that was created to fulfill the need of having an individual with judicial authority for the presentation, the initial presentation of someone taken into custody on a criminal charge, to have advice of rights and fixing a bond. Now, some years ago, the advice of rights was not any extended thing that was done. You know you have the right to an attorney, don't you? And the defendant say yes, and that's as far as you need to go with that. But that system was needed particularly in areas such as ours, where the geographical boundaries of this state are at such distances as they are. So someone being taken into custody in the western part of the state needed to there was need for that individual being taken before a judicial officer who could do these things, fix bond, and then sometimes hold preliminary examination, but very seldom were preliminary examinations held by commissioners. But usually there was a waiver and then what we call a bind over, and the case then proceeded on with presentation to the grand jury and being designated for trial, whatever place of the court was the place it should be designated. So that position here in Omaha was the most active one, of course, because this is the Omaha area is the location where most of the criminal activity historically, the federal criminal activity, has been involved and has been occurring. So there was at the time that that position was combined with the clerk's position here, there was a gentleman here, Anthony Donato was his name, and he had been assistant U.S. attorney some years ago, was a man of some age by this time. He needed a place to hang his hat for a few hours of the day, and so we had a little office for him in the old post office in the Federal Building. And he served that purpose for us. Then ill health finally overtook him. And the judges, district judges, and I, as we talked about it, concluded that we really needed to have someone constantly in the court, in the courthouse that could handle that sort of thing. And so we got permission from the administrative office to combine the position, U.S. Magistrate, with the clerk's office. And I was the fellow who took over on that. And so I shepherded the early activity in criminal cases as it was being conducted at that time by the U.S. Commissioner.
Certainly. The many hats which you have worn over the years, and you're entirely too modest to pat yourself on the back, but now that you're about to step out of office, I don't think it's untoward for a member of the bar to congratulate you and to express appreciation. The many hats that you have worn have included the genuine pioneering work which you did with respect to the development of the office of magistrate. And as I said earlier, this is something that we want to explore at some length in our interview today. Tell us a little bit about the development that went into the creation of this extremely significant office.
Well, the impetus for the creation of the office came about in, it was initiated along about the mid-60s, and there again we have to take into account that that is the time when we were developing sharp increases in civil caseload. And at the same time, there was difficulty in getting created additional judgeship positions, even at a time when the same party was in control of both the executive and the Congress. There was still, as you recall, a very strong division, particularly in the Democrat Party, of those who were from the southern part of the country and those from the north, sliding into what was characterized as a conservative south and liberal north.
Right.
And there was extreme difficulty in getting through the Congress at that time legislation that would permit the creation of additional judgeships as rapidly as they were needed. And so we were suffering from lack of judicial manpower. The Chief Justice, then Earl Warren, and the Director of the Administrative Office at that time were leading an investigative group, sort of informal group, trying to come up with some kind of a solution to this. At the same time, there was fear developing that the commissioner system throughout the country was reaching the point where there was a possibility of there being an adverse reflection upon the court, because the commissioner system was a fee system. And it was blossoming into considerable amounts of fees in areas where there were government installations, and commissioners were handling nothing but petty offense cases that occurred on these government installations. And most of those appointments were made as political favors.
I see.
And so there was concern, particularly by Senator Tidings, who was then a member of the Judiciary Committee of the Senate.
Now that was the original Senator Millard Tidings, was it not? Not the incumbent Senator Tidings.
No, there is no Senator Tidings now. This one was Joseph, wasn't it?
Joseph. Okay.
He had been U.S. Attorney in the District of Maryland, and is a son of the senior.
Eastern fellows correct one way or another.
And and he's no longer in the Senate. But he was concerned about what was happening in Maryland, where some of these installations were, and was also concerned as a chairman of the subcommittee on improvements in the judicial machinery, of investigating what needed to be done in order to modernize the court system. So he started out with the notion of reforming the U.S. commissioner system. And the Chief Justice and the Director of the Administrative Office seized upon that opportunity to do more than just reform the system, and bring it in as a vehicle for creating more judicial manpower that might be of help in meeting this tremendous caseload. So as the hearings progressed before that committee, they shifted from reform to abolishment of the commissioner system and replacement of it with this position known as a full-time magistrate. But there were some constitutional questions that had to be examined as to how much you can delegate to an individual who's not appointed pursuant to Article 3 of the Constitution. And so we had to give consideration to what things that could be done. Well, this exposure that I had from in this district in changing the administrative setup here, and also very soon after the positions of commissioner and clerk were combined here, with my holding both of those titles, we fell upon the notion that since I had all of the trial experience that I had had before I came in to the office, why couldn't I do the pretrial conference work, which the caseload now had reached the point of prohibiting the judges from devoting time to do pretrial conference work.
Certainly.
Now, we couldn't find anything in the law that said I could do that, but at the same time, we didn't find anything that said we couldn't. So Judges Robinson and Van Pelt said, we'll enter a general order. An order was entered that designated me to conduct the pretrial conferences, and so I took hold of the docket from that point on, started scheduling all of the pretrial conference works, conferences, so many as would ever be needed in any particular cases. Did them at Omaha, Lincoln, and North Platte, which then were our three places of holding court. And that came to the attention of the Chief Justice and the Director of the Administrative Office, and so I was then requested to come before the Subcommittee on Improvements in Judicial Machinery. And in 1967, I gave testimony before that committee as to what we were doing. And that had something to do, I like to think anyhow, it had something to do with acceleration of consideration of that legislation. To that point, it was kind of on dead center.
What, if I may interrupt you, Judge, what was the reaction of the lawyers practicing in Nebraska now facing a new magistrate, a person that they'd known in a myriad of other capacities? Were they ever in the position of saying, hey, we want our Article III judge?
To their credit, they never said that.
They knew you, they knew
yes.
your integrity, they knew that you knew your business,
well,
they
I
knew
hope
that you knew trial. Well, they obviously did, or I suppose there would have been appeals from every order you ever entered.
We did not encounter any resistance on that. And as a matter
So bench and bar together, under your direct leadership, helped make this system go.
it was a combined effort of bench and bar, and that should not be forgotten. And the bar of this district is to be complimented on that. They never once did I encounter resistance from anyone coming before me on that for that purpose. And in fact, I took them into to my confidence and asking them for suggestions as to how we might improve it and make the thing work better. And some of those suggestions were eventually incorporated. So it was a wonderful relationship that I've had with the bar.
I distracted you for just a moment because we were getting in a very exciting moment when you were telling us exactly what had happened with the results of this experiment. And indeed, it was an experiment as the word got around to the other powers that be in the country. Well,
now that was the last testimony I gave to them to that committee was in 1967. Magistrates Act was passed in 1968 with a provision that it be implemented on a pilot basis in 1969. And so there were, as I recall it, either 6 or 8 districts that were chosen, a large district and small district, for the appointment of magistrates in those districts, and the other districts were to await a year of experience.
Now somebody had to help those districts, those new magistrates, figure out what to do. Now, do I need to guess very far who that somebody might have been?
Well, there were others, but the law also made direction that training sessions must be conducted by the newly created Federal Judicial Center that was then headed by retired Justice Tom Clark. Training sessions were to be held for newly appointed magistrates, and that still exists in the law, within 1 year's time. The effort was made to create a faculty to conduct seminars, training seminars, immediately. And I was appointed as one of the members of that faculty. Judge Van Pelt was also appointed. His appointment was for the purpose of making presentation in every seminar upon ethics that needed to be observed by judicial officers. My role went beyond that to explain what we had been doing in Nebraska and our imagination as to what more things could be done in districts that may have different problems than what we had in the District of Nebraska. And so we literally, as we traveled from place to place throughout the country holding these seminars, spent time in think tank sessions of what it is the next day we would tell both the Article III judges of that district and these newly appointed magistrates as to what they ought to experiment with. And the law was so briefly worded that it allowed for experimentation and encouraged experimentation. We encouraged the conduct of civil cases by a magistrate who had trial experience if the parties gave consent to do it. Now, eventually that was held not to be constitutional, or it wasn't legal because the Act didn't contemplate it. And so there is a case that went before the Supreme Court in which they said that couldn't be done. Someone who had given consent and lost.
Of course.
Took an appeal. But that's where it started. Now the Act, there were amendments made to the Act, as I recall it. There have been about 5 or 6 amendments made. The last amendment incorporates that very provision about the possibility of the litigants entering into a written consent that trial be before the magistrate, and also that applies both to jury and non-jury cases, and that the magistrate is empowered to enter the judgment, final judgment in the case, and appeal can be taken directly to the Court of Appeals. So that's an example of things that we were thinking up.
Surely.
And eventually have come about. So the field of activity now of magistrates differs throughout the country according to what the particular need of a district is. And even within the district, it differs considerably. There is considerable difference between the scope of activity that I'm engaged in from that Magistrate Peaster is engaged in Lincoln. And that's largely because of the nature of the litigation. Great volume of prisoner litigation, you see.
To be sure.
Down in Lincoln. And he devotes a great deal of time to that. My involvement here in Omaha has been in what now under the Act are called dispositive matters.
Yes.
The handling, processing and handling of summary judgment motions, motions to dismiss, all of the pretrial motions in the criminal work. District judge here never sees a criminal case until all the pretrial activity has been disposed of and the case is either ready for trial or change of plea. And so I do that in the criminal work. And try a number of the misdemeanor cases. There is misdemeanor trial jurisdiction now given to magistrates, and initially it was only to petty offense. Then in the civil work, I am not doing so much now in the way of the pretrial conference work because again we reached the point where the volume overtook us, and we've had to reach the conclusion that there isn't every case that is worthy of pretrial conference. There's some cases don't lend themselves well to a pretrial conference, and they will disappear if you just keep the pressure on for the discovery matters to be taken care of and be rid of them. So I do some of the pretrial conference and a lot of the settlement work. And as an example, we now have being filed before the court well in excess of 100 cases involving claims of injury as a result of exposure to asbestos products in employees of 2 railroads. This is over and apart other asbestos litigation that we have.
My heavens.
And as those cases, as we were alerted to those, they're going to be filed by this particular law firm. The chief judge then was Warren Erbaum, and he entered an order which assigned all of those cases to me for the conduct, the oversight of them as complex litigation, up to the point where either something was going to be tried or, as he said to me, hopefully you get them all settled. And so a great deal of time now I'm devoting to that sort of thing, where we have groups of cases that lend themselves well to that kind of attention.
Now, with respect to other United States districts in this country, you've suggested that, of course, the experience there, perhaps the use of judicial manpower may or may not contribute to the full utilization of a magistrate. Do you suppose it might be true that in some districts the Article III judges are a little reluctant to allow someone else to get on their turf, so to speak?
There is still some of that, but not nearly to the extent that there was initially. And that was a strange thing, that as large as the need was for the additional judicial manpower, at the time the Act was passed, there were serious misgivings on the part of Article III judges to the utilization of magistrates. I guess that Article III judges are the same as any other individuals.
Of course.
There is a jealousy, and I'm using that term now, not derogatory.
I understand that.
But a certain desire to preserve that, quote, judgeship position, and a reluctance to recognize the magistrate as a judicial officer. But experience now has changed that considerably. I have noticed a lessening of that throughout the country, and I really don't believe that it's very prevalent now. Although there is still the reluctance of some Article III judges to even have the term judge applied to a magistrate. And I remember Judge Alfred Murrow, who became the director of the Federal Judicial Center following Justice Clark, was in attendance at a seminar for district judges that was being held, in which he was informing them of what they ought to do about the utilization of magistrate, and really got quite angry with them if said he would be angry with them if they refused to let the magistrate in their district be addressed as judge in the courtroom. We don't hear that now anymore. Initially, you see, there was the problem. How do you address this thing called a magistrate?
You couldn't call him commissioner anymore.
No, is it Mr. or what? And it was Tom Clark and Al Murrow who really took the initiative on that and said they are judicial officers, not Article III, but they are judicial officers.
Of course. And
so they are to be addressed as Your Honor and Judge. And so my attitude about it has always been that that's what the term that better be used in my courtroom, but when someone meets me on the street, why, I'm not offended when somebody says, "Hi, Dick."
Of course, of course. And that's, I think, one of the things that has endeared you to the bar that practices in your court, because they recognize that you are every bit the human being, but at the same time a darn good and tough judge.
I'm glad you said that. I don't know how much validity there is.
I assure you there's a great deal of validity in that. Your intellectual interests have obviously been taken up with the development of this concept, the magistracy, the helping to educate other men and women in the role of magistrate. But it goes beyond that. You've done some other intellectual things. I noticed, for example, that you had written a piece in the Federal Rules decision on the taxation of costs in federal courts.
Yes.
Is this something that just needed to be done, and you said, if nobody else is going to do it, I'm going to do it?
That's the reason it got done. Very soon after I became the clerk of the court, I recognized a problem that the members of the bar were having in handling the taxation of costs that they were entitled to in federal court. It was not something that had been given much attention in the before the federal rules were adopted. And then there was a specific rule that allowed for it, and as the years went by, no one was much concerned with it. But as the kind of litigation changed, and it became more expensive, well, there was an effort, there was cause for effort to be made to see what you could do.
Surely. There
was no work that could be pointed to as to the procedure to be followed in the taxation of costs. There were a number of decisions and reports of what courts had done, but they varied as to how you approached it and what it is that was allowable and what not allowable. And so each time the matter was coming before me, the rule provides for a filing of what's called a bill of costs. And then initially it is to be determined by the clerk with right of appeal to the judge, the presiding judge. That is a judge that presided at the trial. And each time that was happening, I was having to try to educate each member of the bar as to what they needed to do and what they could expect in hearing before me, and then how to proceed when they didn't agree with what I had done. So I came to the conclusion, why not write a law review article? So I wrote an article, and wrote it for the purpose of having it published in the Nebraska Law Review, which then was the only law review in the state. And it was done. And I thought that at least when I got the questions in, what do I do? I'd say, read that article. And that worked. West Publishing then, of course, became aware of it, and the request was made of me to take out the local references in it, make it, revise it so that it would fit, have national application, and they would like to publish it in the Federal Rule of Decision. So I did that, and that's how it came about. No compensation was ever received for it, nor could it be offered, because, you see, I was occupying the position of the clerk of the court. It had been improper for him to offer me anything. The one piece of compensation I got of it, though, was that they began providing me with a desk book of the Federal Rules of Criminal and Civil Procedure that had my name stamped on the outside.
How very nice of them. You mentioned earlier that a number of accomplishments, be they large or small, take place in the federal judicial system, if you will, by virtue of ad hoc or informal committees where I suppose people can let their hair down, get work done. And I've had the pleasure of, privilege indeed, of sitting with you and the other federal judges in the speedy trial work that the District of Nebraska has done. How many other kinds of things like that pull on your time when you're in the judiciary? They take you away from what I suppose the public and the bar looks at as your principal role of deciding cases.
There is much of it. For me, not so much of it anymore. I've withdrawn from it as time went along, and the workload assigned to me became greater. I'm no longer on the faculty of the Federal Judicial Center. I asked to be relieved of that after a period of time. You can do that for about so long until you become a little tired of hearing yourself.
That's right. That's why they have sabbatical for faculty.
Yes, and so I'm no longer doing that. I am still a member of the committee that, and it's an ad hoc committee that considers the drafts that are made by the Magistrate's Division in the Administrative Office of the Courts, the drafts for there is what's called a legal manual for United States magistrates, which must be revised constantly as laws change. And so there are individuals in the administrative office, attorneys there, who work on drafts, then send out drafts to a committee of several of us for us to review and make comment on and suggest for the revision. I am still doing that. That is about the extent of the extra work that I'm doing now. But for anyone that is in the position either of magistrate or of any Article III judge, be district, circuit, or court of claims, or even the Supreme Court. As you know, members of the Supreme Court serve on do a number of things. There is constant request for service of that nature, which never is really recognized outside of the circle that's performing it.
Indeed.
But it's done by the individuals as a matter that needs to be done. You know, there is, particularly in the federal court, and I'm sure it must exist in the state court as well, but because my experience is in the federal court, that's where I know it exists. There is an esprit that exists after you've been on a bench for a while that is uncommon. For the most part, there are exceptions to this. There are some scoundrels that have gotten to the bench. There's no question about that. But for the most part, they are individuals, both men and women, who are devoted to the law and are committed to making, contributing as best they can to the operation of the judicial machinery in a way that will best assure that justice continues to be performed.
Indeed.
In our system.
Indeed.
Now that compels an individual to do things voluntarily or in response to request, absent health condition that prevents you from doing it. That encourages you and almost compels you to respond and do it no matter what individual sacrifice there may be to it.
And I can understand that the psychic benefit from that is marvelous, knowing
Certainly.
that you have participated in something that's for
Certainly.
the good, not only of the district, of the law, of the entire republic, for that matter.
Well, and so at this stage, as I'm about ready to leave this position, the one thought that is uppermost in my mind as I leave it is that while it will not necessarily be recognized by anyone as the years go along, I like to believe in my heart that during the course of that time, I had something to do with shaping the judicial machinery in my lifetime.
Indeed, again, you're too modest, Judge, because you say something to do. Those of us who know of your work and of the roles that you have played recognize that it's a very major role.
Well, thank you.
It has been over these many years. Tell us a little bit about your plans for retirement. I doubt that it's going to be a retirement. You're not going fishing, are you?
No. Actually, my retirement was precipitated about a year earlier than I had expected. It was precipitated by health adversity that my wife incurred about a year ago after open heart surgery. She suffered a stroke with resulting paralysis on the left side of her body. She has made remarkable improvement following a program of therapy which was prescribed, and she, just stubborn individual, has followed it religiously and has reached the point where we think, at least on a limited basis, we can do some of the things that we had been doing before and still had put off to do when I would finally reach retirement. So we're going to do that. I had initially made up my mind some years ago that when I reached the age of 70, I was going to take a hard look at whether it was time for someone else to worry about the things that we've been doing over the past years. It happens it's just 1 year sooner than that. I passed my 69th birthday just 2 days ago.
Happy birthday.
Now, when someone asks me, what are you going to do, the first thing that I'm going to do, because of the date I fixed for the retirement, and that was fixed as a result of the experience in Nebraska that ordinarily we do not have a blizzard before the 1st of December. So my target date is November 30. The first thing I want to do is that when we get that first blizzard during this coming winter, I want to stand in front of the picture window and look out and say, isn't this a beautiful storm? Now, that's just the first thing.
Oh, that's wonderful.
Now, beyond that, there are some possibilities which will be explored as we go. We have already had some discussion in the court as to the possibility of my being available for appointment as special master in litigation that lends itself well to that. Now, that was precipitated that during this past year, the occurrence of 2 different kinds of cases which would have lended themselves quite well to the appointment of a special master. But because of the 2 things, the activity I was already doing and some limitation imposed on me by my wife's health condition, it was not done. And so we've done some consideration that after I feel that I'm ready for it, maybe I would accept things of that kind. There is also the possibility of my expressing interest to those individuals that have something to do with it of becoming an arbitrator. Doing some arbitration.
Sounds like some wonderful plans, and I hope that you would make yourself available to generation or more of students coming through legal education, both at our alma mater, the Nebraska College of Law, and at the Creighton University School of Law as well. One final word, Judge, before we have to leave this extremely interesting visit. Of course, there are people who are concerned with what they perceive as a case glut and judicial manpower things. Surely over your many years of experience, you have observations as to whether we've got things under control. I know we do in the District of Nebraska, but as you view the federal judicial system, do we have things under control? Are we at the lip of needing another rush of more judges, either Article 3 or otherwise? How do you view this?
We're at the lip of needing two things: another district judge, another United States magistrate. We could use it right now.
Mm-hmm.
I anticipate that that will occur before very long. It will have to be done.
Indeed, there is a word at the present time in a collateral matter that we're going to have another bankruptcy judge.
Yes, which has been something sorely needed now. And I understand that that is about to occur. And we need it badly. There is also effort being made now to do the base work that's necessary for the addition of another district judge as well as another magistrate, but those things take time.
Those things do take time.
Yeah.
They do take
I
time.
can't wait for that.
We've had the opportunity today to visit with the Honorable Richard Peck, United States Magistrate for the District Court in the District of Nebraska, a gentleman who has served in a myriad of roles, both in state government and, as we have heard today, in the developing of creative urges, if you will, being at the forefront of the development of the Magistrates Act, serving in a variety of advisory and educational capacities, a man who is about to step down after a long and distinguished career of service. We congratulate you and thank you, Judge Peck, and wish you nothing but the best in the future. I'm
Thank
Richard
you.
Chagru, speaking for the Historical Society for the United States Court in the District of Nebraska.